Do you understand no contact means? That means no direct contact, no email contact, no text contact, no electronic or other messaging contact, no likes on Facebook. You don't even look at their Facebook page.
Yes,
Do you
Your
understand that? Is this
Jackson Holler.
Mr. Holler? This is case number 25CR43212, the State of Ohio versus Jackson Holler. Mr. Holler is before the court with his attorney, Mr. Helbling, Ms. Tranter on behalf of the State of Ohio. Ms. Tranter, what are we doing?
Your Honor, I've had conversations with Mr. Helbling. The state is prepared to offer today Mr. Holler the opportunity to plead to a bill of information. The charge will be it'll be one count of misdemeanor of the first degree unlawful sexual conduct with a minor, being the age difference being less than 4 years. My understanding is that Mr. Holler is prepared to enter a guilty plea to that bill of information this morning. I believe that has been signed along with the waiver of indictment and executed, hopefully being presented to the court. We would ask that the case be scheduled for a pre-sentence investigation and set out for sentencing at a later date.
Okay. Mr. Helbling, is that accurate?
Yes, it is.
Has Mr. Holler been presented with a copy of the actual bill of information?
Yes.
Okay.
Yes, I sent all that information to Mr. Helbling.
Because I don't have a
yesterday.
copy of that
Oh,
in front,
I can get that to you
front
right now,
of
Judge.
me.
Yeah. I've
All
got a
right,
copy.
Mr. Holler, they're telling me that you are going to be waiving your right to have your case heard by the Warren County Grand Jury. You've seen the copy of the actual bill of information, is that correct?
Yes, sir.
This document charges you with one count of unlawful sexual conduct with a minor, which is a misdemeanor of the first degree, carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Are you aware of that maximum penalty?
Yes, Your Honor.
And then I have this document here called a waiver of indictment. Is that your signature?
Yes, Your Honor.
Did you sign this document and review it with your attorney before you signed it?
Yes, Your Honor.
Did anyone promise you anything or threaten you in any way to get you to sign that document?
No, Your Honor.
You understand that you are entitled to have your case first heard by the Warren County Grand Jury to determine whether there is probable cause sufficient to require you to stand trial for a charge. Do you understand that?
Yes, Your
And
Honor.
you wish to waive that grand jury proceeding, waive the indictment, and proceed directly with the plea?
Yes, Your Honor.
All right, very good. Are you under the influence today of any drugs or alcohol?
No, sir.
All right, the court's going to make a finding that you've made a knowing, intelligent, and voluntary waiver of the indictment process. Now, with regard to the change, or for the plea, it's not really a change of plea because you haven't entered a plea yet. I have this document. It's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, Your Honor.
Did you read this and go over it with Mr. Helbling?
Yes, Your Honor.
And you believe you understand what it says?
Yes, Your Honor.
This document says, as I've indicated, indicates you're going to be pleading guilty to one count of unlawful sexual conduct with a minor, misdemeanor of the first degree that carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalty?
Yes, Your Honor.
You will also be required to register as a Tier 1 sex offender. Do you understand that?
Yes, Your Honor.
All right. Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury. They are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
Now, the burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. The standard applies to each of the essential elements of the charge, in this case from the bill of information. Do you understand that?
Yes, Your Honor.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights we've discussed?
Yes, Your Honor.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, Your Honor.
This is how you want to proceed.
Yes, Your Honor.
Ms. Tranter.
Your Honor, this incident occurred November the 25th of 2025, Warren County, state of Ohio. On that date, the defendant, Jackson Joseph Holler, was 18 years of age or older, did engage in sexual conduct with another when the defendant knew or had reasonable cause to know that the victim was between the ages of 13 and 16 or was reckless in that regard. Furthermore, there was less than a 4-year age difference at the time of the offense.
Victim has approved of this modification?
Yes, Your Honor, victim has approved. As well as he is a minor, and I'll put on the record that in addition, the parents are in agreement as well.
Mr. Helbling, anything on those facts?
Nothing on the facts.
Mr. Holler, did you hear the statement that she read?
Yes, Your Honor.
Do you admit and acknowledge that what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed.
Yes, Your Honor.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts of your plea, the court will make a finding of guilty. I will order a pre-sentence investigation. We'll come back in a few weeks to do sentencing at that time.
Is there a way to, that the court could reduce the bond? To
Your
allow-
Honor, I am prepared to have the hearing. I have spoken with the victim and the parent at this time, so if Mr. Helbling wishes to address bond, we can do so.
Yes, I'd like to see if he could be released on his own recognizance, Judge, in light of the fact that he's already pled. He does have his grandmother that he will be staying with. He's provided me the address of that. Given the facts and circumstances of this, I think it would be appropriate on the misdemeanor.
Your Honor, the state as well as the victim have no objection to him being released on bond today, as long as the court does impose a no contact order.
We're not opposed, obviously, to that.
All right, I will order Mr. Holler released in his own recognizance at this time. You will be on pretrial supervision, Mr. Holler, so as soon as you are released from the Warren County Jail, you are ordered to report to this building and check in with court services. Is the state requesting a monitor? Is that necessary?
I don't think that's necessary, Judge, as long as we get the no contact
You are to
order.
have no contact with the victim or the victim's family in this case. Do you understand me?
Yes, Your Honor.
Do you understand no contact means? That means no direct contact, no email contact, no text contact, no electronic other messaging contact, no likes on Facebook. You don't even look at their Facebook page.
Yes,
You
Your
understand that? No one else, you're not allowed to have someone else contact them on your behalf. Any of that would be a violation of my order, and you'll be back in the Warren County Jail. We clear?
Yes, Your Honor.
All right. Mr. Helbling, anything else?
Nothing. Thank
All
you,
right,
Judge.
that's all.
Under Ohio Revised Code, Section 2907.04, unlawful sexual conduct with a minor can be charged as a felony or a misdemeanor depending on age difference. Here, the state proceeded by bill of information, which is permitted when a defendant knowingly waives indictment under Criminal Rule 7, subsection B. The court confirmed that waiver on the record and properly exercised jurisdiction to accept the case without grand jury action. The guilty plea was taken in compliance with Criminal Rule 11, with the judge advising all constitutional trial rights, the maximum jail exposure of 180 days under Ohio Revised Code, Section 2929.24, and potential fines under Section 2929.28. The court also advised mandatory Tier 1 sex offender registration pursuant to Ohio Revised Code, Chapter 2950. After accepting the plea and entering a finding of guilt, the court ordered a pre-sentence. An investigation under Ohio Revised Code, Section 2951.03, which allows the court to gather background information before imposing sentence. Bond modification was addressed under the court's pretrial authority. With no objection from the state or the victim, the judge exercised discretion to grant release on recognizance, condition on pretrial supervision, and a strict no-contact order, enforceable under Ohio Revised Code, Section 2937.222. Any violation of those conditions exposes the defendant to immediate jail and revocation of release. Sentencing remains pending with full discretion reserved to the court within misdemeanor limits.